did. I had 2 cups today.
All right, guys, I've got 7 o'clock. Welcome back to class 2 of legal drafting. An exciting semester. I can't believe it's January because it's like 60 degrees outside. It's crazy. I'm worried that one of these drives is going to be in snow, but so far so good, so we'll see how it goes. Has everybody been able to get on Twin? It looks like a lot of you all have registered, and I know that because I can you all see this email option too? You know, like send an email to one of your classmates. Is that available to the students as well? So if you want to be like, hey, so-and-so, let's grab a coffee, I can just find you through Twin. No, that's not. It's not a social networking site. But anyway, it looks like a lot of you have registered. If you're not on here, you definitely want to get logged on to Twin and sign up for the course, just because this is how we're going to, most commonly correspond with one another, at least in a formal way. The syllabus, of course, is there. Seems like you might not need that throughout the course of the semester, but if you think that, you'd be wrong, because the last page of the syllabus is going to be continuously updated as we go throughout the semester, just to reflect the schedule that we're going through. And you'll see I've already posted up through the 3rd class, which is going to be on January 27th, so that's been updated. The drafting exercises folder, I moved that up to the second part here, because mentally it made sense for me to have you all think first about drafting exercises, because those are going to be due typically on the Saturday after we meet. So like we're having class today, we're going to talk about good legal writing, and then you're going to have a drafting exercise that's going to be due by Saturday. This is, of course, a unique week because we've got the MLK holiday on Monday, a week from today. So everything is kind of pushed back a week, so you get a little bit more time. So your drafting exercise, instead of being due this Saturday, will be due on Saturday, January 25th by 5 o'clock. So you could click on there, and we'll talk about this at the end of class, but you can click on there. The drafting exercise is posted, as is the Nettles-Nickerson case and the Belogan case, 2 cases that you're going to have to read in order to complete the short, not difficult at all drafting exercise. That is mostly opinion-based, so, preview. Spoiler alert, it's not stressful. Reading assignments, after you do your drafting exercise, then you're going to turn your attention to the reading exercise, or the reading assignment for the next class. We've already posted the reading assignment for today's class, and then the reading assignment for the next class, which again is not for 2 weeks because of the MLK holiday. That is this short article on general introduction to litigation-related documents. So that's all there. So our game plan for today is we're going to have a discussion about the reading. So you did the reading on Good Legal Writing, the Plain Language Act, and this piece on A Philosophy of Drafting by Professors Cooney and Looper. We're going to talk about those, talk generally about good legal writing. Towards the end of class, we'll introduce the drafting exercise, which will be due by Saturday at 5, not this Saturday, but the following Saturday, and then we'll briefly introduce the reading assignment for next class. This class will serve as a good introduction, I think, to tips for good legal writing, which will hopefully serve as a foundation for the rest of the class. Any questions about what we're doing, where we're going? Okay, so what I did was put together a PowerPoint. But first, before we get into good legal, would somebody pass around an attendance sheet too? Just like a sign-in sheet, you can just write your name. Write it clearly so that I know, who you are. Any questions, concerns, comments? Okay. I wanted to begin by kind of stepping back and giving you an overview of all of the documents, again, we're going to be discussing. We talked a little bit about this last class when we introduced the syllabus, but I think it's kind of worth thinking about this in more of an outline type format. We're going to spend today kind of doing an introduction to civil litigation. The introductory materials that we're going to talk about today focus on good legal writing, but the first kind of category of documents that we're going to look at in the drafting course are documents that fall under the broad category of civil litigation. And so we're going to introduce civil litigation really more for next class. When you got next class is the one where we're really going to start thinking, okay, we're in the world of civil litigation. What does it look like? And we're going to kind of get a broad overview of things like complaints, answers, motions to dismiss from both lack of subject matter jurisdiction or failure to state a claim upon which relief may be granted, or some other lack of personal jurisdiction, some other bases for dismissing and complaint. We're going to talk about other things. But next class is this kind of broad general introduction to civil litigation. And so we're going to look at complaints, right? What are some of the tips and things you need to keep in mind if you're drafting a civil complaint that's going to be filed in state or federal court? We're going to talk about that during the course of the semester. We're going to look at answers, right? What you'll see, just as a short preview, is with complaints and answers, I would say those are the two documents we're going to look at that are the most technical in nature. And what do I mean by that? I think that it's fair to say that there is some leeway. There is just room for style in how you draft all sorts of documents, right? Motions or emails or memoranda or, judicial opinions, certainly this is true. There is a lot of flexibility, I think, in how you draft those documents. Complaints and answers, there's certainly some flexibility, but there are kind of more technical rules that you're going to have to keep in mind with respect to both documents. When it comes to complaints, you're going to be thinking about drafting factual allegations that go to each of the elements of a cause of action. So I deal with a lot of prisoner submissions in the Eastern District of Kentucky. We get a lot of filings where people are alleging all sorts of things that are happening in prison. And one example might be that someone is claiming that they're incarcerated and they have diabetes, and just making this up, and prison officials are not giving them the insulin that they need to treat their medical condition, their diabetes. And so the prisoner wants to allege, or is claiming, that the defendant prison official or prison officials ran afoul of his constitutional rights. And what constitutional right would that be? Well, maybe the Eighth Amendment, right? The Eighth Amendment prohibits cruel and unusual punishment. And the federal courts have actually interpreted the Eighth Amendment as providing a cause of action if you can allege deliberate indifference to your serious medical needs. So you have to say, I have a serious medical condition, and the defendant is displaying a deliberate indifference to that medical condition. If you can kind of prove up those elements, then you maybe could make out an Eighth Amendment claim. So that's, if you are, let's say, representing a prisoner who had such a case, those were kind of the rough factual allegations, and that was the legal claim you were thinking of. If you were drafting a complaint, it would have to be somewhat technical in nature, right? You would want to, and this will all become clear as we discuss complaints, the first substantive document that you'll be drafting. You will have to draft a document where you have numbered factual allegations that establish both a serious medical need and that the defendant displayed a deliberate indifference to those needs. So what you may say is something like number one, plaintiff Paul Smith has diabetes. Number two, plaintiff Paul Smith has been incarcerated since January 1st, 2015. Number three, number four, and you would go through and lay out in a just very neutral way specific factual allegations that, if true, all of those at the end would make out a cause of action for deliberate indifference to serious medical needs, would make out an Eighth Amendment claim. Or if you were doing a contract case and it was a breach of contract, you would have specific factual allegations that would prove up the existence of a contract, offer, acceptance, consideration, and that established a breach of that contract. Or if it was a tort claim, factual allegations that went to each of the elements of a cause of action for negligence, let's say, or assault, or battery, or whatever the case may be. Those are very kind of technical, right? And we'll learn about that. Answers, likewise, are also technical, but the sense there is what you're doing is responding in numbered paragraphs for people who have had, raise your hand if you know what I'm talking about, kind of, so you guys are like, okay, what the hell is going on? But this is, we've got to be kind of thinking in a very technical way, because these tips can apply to all of these different contexts. But with an answer, you're thinking about numbered paragraphs or numbered paragraphs that respond to each of the plaintiff's allegations. So you're going to admit allegations or deny allegations or indicate to the court and to the opposing party that you don't have enough information to respond adequately to the factual allegation. But I think it's also pretty technical, right? A little bit less leeway. You start to then get more leeway when you think about things like motions, right? And there are a variety of motions that get filed really at all stages of civil and criminal litigation, but we're talking about civil here. The ones we're going to focus on are things like motions to dismiss, right? Maybe you get a complaint, and that can also come at different stages of the litigation, but we're going to be thinking about a motion to dismiss kind of as a responsive pleading in lieu of an answer. So plaintiff files a complaint, let's say in federal court, making specific factual allegations. Instead of the defendant coming back and filing an answer in response, the defendant could come back and file a motion to dismiss and say, hey, pursuant to Rule 12 of the Federal Rules of Civil Procedure, the defendant, moved to dismiss the plaintiff's complaint, and here's my reason for doing so. And so we'll talk about things like motions to dismiss for failure to state a claim, motions to dismiss for lack of subject matter jurisdiction. 12b1 is subject matter jurisdiction, 12b6 is failure to state a claim. And what those look like. That, I would say, has a technical aspect to it, but how you write a motion to dismiss that's going to be filed in federal court and served on the opposing party, they look very different stylistically, and I think is somewhat in tone. And so what we're going to see is that the tips for good legal writing really, I think, they get going throughout the course, but they really start to take hold in motions because you kind of lose a little bit of a raft here. Like complaints and answers feel like if you kind of follow the format, if you do the reading kind of closely and kind of follow the format, you can kind of do it. Anybody can draft factual allegations. When you get to motions to dismiss, I think students tend to want to kind of fall back on their lifeline being the IRAC method, right? The issue in this case is whether we should dismiss the plaintiff's complaint for lack of subject matter jurisdiction. Well, the law in subject matter jurisdiction is diversity or federal question jurisdiction or whatever. And let me lay all that out, and then let me apply it to the facts of the case, and then let me come to a conclusion. And that's not wrong, but that's kind of where legal drafting, which is the course, right, really kind of also meets writing, right? Because I think, in a way, it's kind of interesting. When I prepare for this class, and certainly when I prepared last semester for the class, and just think about legal drafting, the word legal drafting makes it sound like drafting, like technical, right? Like I'm going to draft something, like draft architectural plans for a house, or draft. Do you know what I mean? Like draft is like not write. Write is like create and be artistic and tone. But what I'm here to kind of tell you is like, no, drafting is writing. You guys are looking at me like I'm crazy. Does that make sense though? Like if you signed, and spoiler alert too, if you signed up for like contractual drafting, that's not really this course. It's not. This is like litigation drafting, or to some extent like informing and persuading drafting. It's really the stuff that I think you're going to be doing. That like the bulk of you coming out, really no matter what kind of law you're going to practice, even if you're doing like transactional stuff, you're still going to have to like write an email to your supervisor or draft a memo or file a motion in court presumably, or at least take a short stab at a motion for someone else. So the tip here is complaints and answers do start to feel like that technical type of drafting. When we get to motions, it really starts to kind of fade, not completely away, but it's less technical and it's more writing, right? A motion for summary judgment, right? That could be a very challenging assignment because motions for summary judgment typically are at the close of or the conclusion of a discovery process, right? Where both sides have had the chance to look at documents and depositions, and both sides have kind of opened each other's files, and there's been this long kind of discovery process, interrogatories, written answers, and the depositions, and all the witness statements, all sorts of discovery, photos, and all sorts of evidence is piled up. and then we're going to look to that evidence and then move under Rule 56 for summary judgment in one party's favor. It's a little bit hard to kind of replicate that in this course just because, we're not going to be opening up piles of evidence. But we will talk about motions for summary judgment. Then, of course, there's non-dispositive motions, right? I mean, they're all every day when I open my work computer, it's like motion, and it's like, stop, asking the court for stop. Let's get coffee and just relax. But people are asking the court for everything. Motions in limine, motions to suppress, motions to recuse, motions for a change of venue, fee-related motions, all sorts of motions. We'll touch on some of those and talk about some tips for drafting those documents, but I think motions to dismiss will get us a lot of the way there. There's also discovery-related documents, which I mentioned, but it's really, for us, the news is all in A, B, C, 1, okay? Then, once we kind of close out our discussion of civil litigation, we're now approaching March at this point in our timeline, maybe even a little bit after that. We're going to touch briefly on criminal litigation and just talk about the types of documents that are at play within the world of criminal litigation. So things like indictments, plea agreements, motions to suppress, jury instructions. These are just a few of the documents you see in criminal litigation. This course is not heavy on criminal litigation-oriented documents, and I think a lot of that is because those documents, to the extent that you're working on one side, the prosecution, those are documents that are going to have to go through their own kind of drafting process within the confines of the, U.S. Attorney's Office or the County Attorney's Office, and it seems like wrong to stand up here and try to teach students how to draft an indictment, and then if one of you ends up going to work for the U.S. Attorney's Office, they're going to be like, that's not how we draft indictments. We would never do that. Whereas I think I can say, look, here's kind of how, there's no one right way to draft a complaint. And it's not that the U.S. Attorney's Office gets it wrong ever. I'm sure they do. I know they do. I've read some of the work. No, they're great people. But I think they have their own, it's not wrong for them to go through their own process, right? They clearly have that. That's the proper way to draft an indictment. It's not to rely on your notes in legal drafting at 7 p.m. from Mondays 3 years ago, earlier, So anyway, but we'll talk about criminal litigation. So the first category is big, right? Civil litigation-oriented documents. The third category is big for us, and that's this kind of a little bit of a mushy category, a little bit of a gray category on informing and persuading. But those are documents like emails, office memoranda, trial and appellate briefs, and judicial opinions. This is a big ticket item for us because although it may sound like hokey, like you're going to learn how to draft an email, what you'll see really is that the difference between emails, office memoranda, and I would argue to some extent judicial opinions is really not that significant. Now I know that sounds crazy. You're thinking how could a judicial opinion not be different than an email? And what I would submit to you is all of these will involve some sort of fact pattern and substantive legal question that needs to be resolved. And what we're going to learn is really about the best way to take a fact pattern, a body of law, and apply the law to the facts in a way that's both informative, but also very persuasive. And I do think that there is almost a technical approach to that. And I kind of introduced that last class with my mild attempt at humor, which is comparing Quills and Starbucks, right? That's just one example, right? Or if I wanted to compare two of anything, or if I wanted to choose A over B, or any answer persuades you of something, right? Which is really, you might get an email that's like, hey, tell me the status of the law on this, and I'm not going to tell you anything about my fact pattern. In which case, maybe you would put just a substantive legal memo together, here's what the law is. You don't really get that much of that. It's usually hey, this neighbor has his fence 5 inches over the boundary. What can we do about it? Or this situation is going on, and tell me the answer to this question. That could be a short email. It could turn into more substantive memoranda, or it could be the whole case is before the court and it's resolving maybe a very substantive motion. it all could, and I would argue should, take roughly this same kind of top-down, I'm going to say this about 600 times this semester, so get ready. People will run out of the room. Top-down, kind of bottom line up front, proof-like way of writing, right? Which is the answer up front, and it's not conclusion rule analysis conclusion, right? Do you guys know about that? CREAC? Yeah, that's not this. See, students are like, oh, well, all you have to do is just move the conclusion to the front, and then it's all bottom line up front. Well, that's true, the bottom line's up front, but then it's just like the answer to the scale. Well, let me give an example. Let's just go with the negligence one, because it's easy. Everybody knows duty, breach, causation, damages, right? The defendant is negligent, period. The law on negligence is blah, 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 blah. And it goes on for like 3 paragraphs that are boring and nobody wants to read. And you're like, how does this apply to the facts of the case? And then it's somewhere along the line, like 4 paragraphs down or 5 paragraphs down, there's a paragraph that begins, in this case, or here, or applied to these facts, comma, and then you analyze each of the elements, right? That's what I'm saying you know about, or you should know about, right, to answer a law school exam question or the bar exam. So don't lose that. But what this is saying is take that really good kind of course. This is what happens when you, wow. Take that IRAC, or if you wanted to put like CREAC or crack, I don't know. Take the crack and turn it into something good. That'll be the quote of the day. When I was a law student, we had something at UK called the TWIB, the Week in Brief, and it was a student newsletter that the Student Bar Association president ran, and it had a funny section in there called quotes, professor quotes, or student quotes, but you didn't want to make it as a student. And it was always professor quotes, and the professor quotes would make it in there. And then it was funny. And then I ended up teaching as a visiting professor at the law school at UK. And every week I would say something, and like that, like, oh, turn your crack into something. And then the other faculty was like horrified. They were like, what are you talking about in class? Crack cocaine? And it's like, no, it was a point. And I got emails, and it was really embarrassing. Try not to quote me. Maybe Louisville will be quote free. Who knows? Try to take this IRAC approach and turn it into something. This is informative, right? I mean, you can make a substantive argument. You can make a pedagogical argument or a functional argument even that this is informative, but it's not persuasive. Why? I need to stop talking. I mean, we got a lot to talk about here. Why is this not super persuasive to you? What to you is the problem in saying, like, the issue in this case is whether you should go to Quills or Starbucks? The law on Starbucks is, blah, blah, blah. Let me tell you about the rules and the price and the coffee and how it's roasted and all that stuff. And then the location. And then let me talk about the location of this other place and this and this. What's the problem with that? Or in the negligence context, or what's any reaction to this as maybe not being the best way of writing? I mean, it's a little rogue. We're going a little rogue here at like 7:30 on a Monday. Like, I'm coming in here and I'm kind of saying, this is bad. Not bad, just not persuasive. Am I wrong? Should they run me out of here? I mean, they don't pay a lot, so I'm just kidding. What do you think?
Is it because the persuasion part comes so late, like in the argument?
What do you mean by that?
Like,
I think that's persuasive.
Towards the end, you're taking this person through a whole journey, and then you're finally telling them, like when you did before, you kind of told us, this is why it's better. These are 3 reasons.
Yeah, I mean, I do think that, if ultimately you're trying to persuade someone of the answer, burying it down here, really maybe 3/4 of the way through your analysis, you might not even be deep into the analysis before you think, hey, maybe that's the right answer. You can move the conclusion up front, but all you've done is set the conclusion. You've hardly done anything. You may have done nothing to prove it, right? Like, you should go to Starbucks over Quills. And then I said, but ignore that. I'm going to tell you all about both of them. You're like, no, why? Tell me why. I think you've got it. Any other reaction to that? I think related to that is this tends to be long and really, really boring, right? It's boring. Like, has anybody read, you've read these cases, and we'll read some of them, where it starts, and there's a whole section that's like standard of review. I never read that in law school, anywhere. I'm just like, that's a nightmare. And then it's like quotes to all sorts of cases, like Celotex, and Liberty Lobby, whatever, blah, blah, blah. It's like, are people reading that stuff? No. And then there's like string citations, and then quotes in the parentheticals. If you're doing that, that's insane, right? Nobody's reading your string citation parenthetical quote. Like, if you're trying to bury persuasive stuff in that, forget it. Nobody's reading it, right? This is long. It's also confusing. Why is it confusing? Let's say I'm trying to persuade you that A is the right answer over B, and I've got 3 reasons, right? I could give you those reasons up front, which would be super persuasive, or I could do a stupid thing, which would be to teach you all about these choices and give you so many things that you have to keep in your mind, right? Like, I could tell you all about the location of Starbucks and the price and how they roast their beans and how they are really kind of treat their employees in a really positive, progressive way and how they do this and this and this. But I could just not argue anything. I could just say it all with respect to points of law. And you're trying to like keep it all up here and hold on to it, right? And yeah, you might end up using some of that later, but what are you going to use? Right? I mean, you've read these long paragraphs on, let's say, causation, right? You might have a paragraph on law on causation. Well, there's 2 types of causation. There's but-for causation, and then there's proximate causation. With respect to but-for causation, that means that blah, 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 blah. See this case. But it also means blah, 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 blah. See this case. Second, there's proximate cause. From the Palsgraf case, that means legal cause, which is foreseeability, zone of circumstances. You're like holding all this up there, pages of like information, and you're like, how does it apply? How does that apply? It's not persuasive, right? It's not persuasive. It's more persuasive to, in an upfront way, say this is the answer. People are walking by thinking, what the hell's going on in there? It's fine. I've had it before. I'm crazy, but just go with me. You will be on this bandwagon. You'll be running around next semester and be like, don't do Iraq! I know, crack! No, not crack! Okay, so, but it's more persuasive to say up front, this is the answer. And here's why. See, he was in my class. He knows. See? They know. Okay. It's more persuasive to say up front what the answer is and say why that's the answer. And typically, in most cases, that involves discrete reasons, right? And if you say up front, this is the answer, and here's why. It could be, the answer is Starbucks is better than Quills for 3 reasons. 1, 2, 3. And then your next paragraph is going to be the first reason. And then you're going to have kind of an intersection of law and facts in your paragraph. You know, the first reason is because Starbucks has more locations than Quills, and thus is more convenient, period. After all, Starbucks has 1.2 billion locations across the world, period. See this case. Right? So you're being informed about something, you're learning about something, but it's taking that law or that point of information and it's using it to support your argument, right? And you might have to deal with counter-arguments, right, along the way. It's true, however, it is true that blah, 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 but that's wrong because of this. Blah, 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 blah. In conclusion, this. Second, and then you go to the next one, and then the next one. So, but whether it's an email, a memo, or a judicial opinion, it all functions the same way. You don't have to write an email in a less persuasive way than a judicial opinion, right? And it could be discrete reasons why one thing is the right choice over another. It could just be simply that the defendant prevails, or the plaintiff prevails. And in the negligence context, right, you're not like, you're not making a list of reasons why the defendant wins or the plaintiff wins. You're establishing each of the elements of a cause of action, which is actually more common for you all, right? So your judicial opinion, let's say you had a judicial opinion and you're the judge and you have to decide, was the defendant negligent or not? You could write an opinion like this, or you could write an opinion that starts out by saying, brief introduction into what's going on, maybe just a few sentences, and then get immediately to the heart of it, which is the defendant was negligent in this case, period. That is because the defendant owed the plaintiff a duty of care, the defendant breached that duty of care, the defendant caused the plaintiff's harm, and the plaintiff suffered damages. Now, what's your next paragraph going to be? Anybody? Come on. Somebody? So that's your answer. That's your bottom line up front. Your proof-like thing is the defendant was negligent, period. That is because the defendant owed the plaintiff a duty of care, the defendant breached the duty of care, the defendant caused the plaintiff's harm, and the plaintiff suffered damages. That's all your first paragraph. What's your next paragraph going to be?
Here's how.
Oh, kind of. Yeah. The defendant owed the plaintiff a duty of care, right? Now, what's going to be the next sentence after that, right? That's your first paragraph. Your second paragraph is going to start with the defendant owed the plaintiff a duty of care. What are you going to put after that?
Why?
Why? Yeah, something like that is because, and then you'll say why. That is because the defendant was a landowner, comma, the plaintiff was a invitee, comma, and under the law, landowners owe invitees duties of care. I mean, that's probably totally wrong. Well, no, it sounds right. And then you would cite the case, right? Do you see that? Do you see how that's like all persuasive? None of that's like blocks the law. The law's going to be in there. But it's being used to prove what you're trying to prove. This could be done in life, right? I mean, listen, where should we go for lunch? Well, we should go. Then you do this in your own life. Should I go to Florida or Louisville for law school? Well, you should go to Louisville for 3 reasons. What are they? One, Florida's got a lot of gators. I'm scared to death of gators, right? Florida has a lot of gators, period. After all, a study from the Fish and Wildlife said that blah, 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 blah. And it doesn't just have to be a choice between two things. It could just be the answer is this. It's all kind of a choice, though, right? If you're trying to persuade somebody, if the defendant wins or the plaintiff wins, you have to prove up the elements. But you wouldn't say, well, the issue in this case is whether I should go to Louisville or Florida. Let me tell you. Let me just go through that. I mean, maybe you talk to your friends like this. Maybe you're like, just hear me out for 15 minutes on both schools, right? And maybe two parties are arguing. Maybe there's like maybe there's like the mom. My mom decided everything. Probably not a good idea, but she would decide things, and my brother and I would bicker. And then imagine like we would just lay it all out, and then she would rule. And she could rule and say, well, all right, I've heard you for 15 minutes, and let me tell you what you said. No. She'd be like, this is the answer. We're having spaghetti, right? Because it's cheap, it's in the pantry already, and because I said so. Does that make sense? This is a law school exam thing. This is a bar exam thing. This is what we're going to be doing a lot of, especially from motions onward. Complaints and answers, it has to be more technical, right? It's got to be like factual allegations and admitting and denying. So we're going to do some of that. But this is where it's at. This is good legal writing. And you know what? If you come away with even just an appreciation of that in this class, you will have succeeded because you will go out in the world and you will read, and this is not a knock on anybody, but you will go out and read judicial opinion after judicial opinion, and they are terribly written, horribly written. You're like, oh my God, this is like this on steroids. This is like Iraq! Iraq! And then little AC. You're like, I don't care. I don't want to read all this. Why is this the right answer? You know? I'd rather just read affirmed, period. Get the hell out of there, because I didn't read it anyway. Okay, so that's what we're doing. All right, other documents, we'll talk about these, but this is just not the jam. This is not where like the class is, right? It's this. This is the class. And you will appreciate this and do it, and you will practice it, and you will edit it, and you will try again, and it will all be great by the end. Any questions about that? That took longer than I wanted, but it's, I think, worth discussing. Questions? Let's get to the reading. Okay, what are we doing now? We're going back to the beginning. We're going to talk about the introduction, the pre-civil litigation talk, and then we'll look at general introduction to civil litigation. So let's look at that now. The introduction. Our starting point here is, and I love some of these quotes, we're going to look at the Osvet piece first. This is really kind of this is like, maybe this is an exaggeration, but for me, as like a legal drafting person, a legal writing person, this article is like to legal drafting as like international shoe as to, you know, maybe not that foundational. But, and people are like, oh, well, then it's going to be terrible. International shoe can hold its own. You know, minimum contacts. Okay, let's give a shout out. All right, but 420, I kind of like this. Many state and federal judges and others have noted the poor writing skills of lawyers. I like this I like this quote on page 420. Judge Edwards faulted law schools for not providing their graduates sufficient training in the skills they would need to practice law, and raised his serious concern concerning the lack of good training in legal writing. In my 12 years on the bench, I've seen much written work by lawyers that is quite appalling. I've seen a lot of work from girls that are kind of appalling. Many lawyers appear not, don't say that though, to them. Many lawyers appear not to understand even the most elementary matters pertaining to style of persuasion in legal writing. I think that's right. I mean, Posner has also said he's seen writing that's often quite bad, sometimes awful. You know, the place I really learned this, honestly, was from when I clerked. The judges that I clerked for were all about this, especially Judge Rogers. I mean, this was his whole thing. And I think if he were kind of channeling Posner, which I don't know that he ever would, but if he was channeling Posner, I think he would say what he's getting at is this just kind of long piece of writing. You guys must have read stuff like this in some of these case books. Like, I mean, first of all, just like, well, I mean, I love Dean Chemerinsky. He's like, I'm just going to put it all in there. And we should just read the Constitution. Right? The Constitution law, let's just start there. But it's like just this long-winded piece of writing where it's just boring, and you're at page 22 of 57, and you're buried in like this third standard of review section about abuse of discretion, and you're like, what is happening? Nothing good. Nothing good is happening. It's just really that, but I think that there's something about it that continues to stand the test of time. This lengthy, legalistic writing that is not clear and loves Latin words, assuming arguendo. No, okay, don't do it. You sound stupid. Right? Because most of the time it's used poorly or incorrectly. But also just because it's not clear. You want to not only come out, part of the reason why this is, I think, a good way of writing is because it's like short and punchy and doesn't include superfluous stuff, and you don't need to bury extra rules in there. It's not like, oh, it's not like throw in some extra milk into the smoothie and it'll taste good. No. That's not what we're going for. We're going for concise, tight, crisp writing that includes really only what you need and none of what you don't need. So that, I think, is what a lot of these judges are getting at. But that's the starting point.